I declare open this hearing of the Senate Economics Legislation Committee inquiry into the Competition and Consumer Amendment Unfair Trading Practices Bill 2026. I begin by acknowledging the traditional custodians of the land on which we are all respectively meeting and pay my respects to their elders past and present. And I extend that respect to Aboriginal and Torres Strait Islander peoples who are participating today. The committee will be conducting today's hearing via video and audio teleconference. So we have senators, I can see Senator Charlotte Walker, who is online, and Senator Little, Deputy Chair, who is on the phone, and I believe Senator O'Neill may be joining us at some point. These are public proceedings being video streamed via the Parliament's website live, and a Hansard transcript is being made. I remind all witnesses presenting in Australia that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinion on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. And I would now like to welcome representative, I think it's just one representative from the Telecommunications Industry Ombudsman, Ms. Cynthia Gabbett. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Chair. Cynthia Gabbett, Telecommunications Industry Ombudsman.
Thank you, Ms. Gabbett. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Thank you, Chair, and thank you to the members of the committee with us today. I appreciate the opportunity to appear. The Telecommunications Industry Ombudsman is Australia's independent external dispute resolution scheme for the telecommunications consumers. We assist individuals and small businesses to resolve complaints with their phone and internet providers. We welcome the protections against unfair trading practices in the Competition and Consumer Amendment Unfair Trading Practices Bill 2026. We support a clear prohibition on unfair trading practices and stronger protections for consumers in subscription contracts, including their application to telecommunications and digital platforms. Through complaints to our office, we see firsthand the practices that can cause harm. We consider that the bill will strengthen consumer protections, increase consumer confidence, and importantly, prevent complaints before they arise. To illustrate, between 2023 and 2025, we received almost 14,000 complaints about failure to cancel a telco service. These complaints often involve complex cancellation processes and retention practices that pressure consumers to stay in services they do not want, waste their time and cause financial and emotional harm. Take, for example, a consumer that we'll call June. June is 90 years old and recently moved into an aged care facility. When June moved, her daughter tried to cancel her telco services for her. Despite receiving assurance from the telco that the service had been cancelled, they continued to automatically direct debit money from June's bank account. Eventually, June had to cancel her card so they would stop taking money from her account. June later received a notice that from her telco, saying that it was suspending her services for non-payment. In order to properly cancel the service, the telco told June she needed to go to a store, which was not possible for her because she could not leave her aged care facility for medical reasons, and the nearest store was about 25 kilometres away. This case study is based on common examples of the detriment we see from unfair trading practices. We therefore strongly support the bill's approach to unfair trading practices, including the current drafting that removes ambiguity and better captures conduct that manipulates consumers. We also support the bill's provisions on its subscription contracts, including improved disclosure, cancellation rights and requirements for online cancellation. These measures address common sources of consumer harm, such as unintended renewals and barriers to exiting services. However, based on our complaint data, we consider there are opportunities to strengthen the bill further. In particular, providers requiring consumers to opt into renewals for longer-term contracts and ensuring cancellation is available through the same channels used to sign up, so exiting a service is not harder than entering it. We also look forward to making a submission to government on the possible extension of the general prohibition to small businesses. The financial stress and detriment caused by unfair trading practices can have severe impacts on small businesses. For example, small businesses finding themselves in long contracts with high exit fees and being unable to cancel and incurring fees for the services they are no longer using. Finally, we note that similar harms are also emerging in digital platforms. While this is outside our current jurisdiction, consumers are contacting us with ongoing charges, undisclosed fees and difficulty cancelling subscriptions with digital platforms, and they don't know where else to turn. In closing, we support the bill and its progression through Parliament, and we welcome the opportunity to assist the committee in strengthening these important consumer protections.
Thank you very much, Ms. Gabert. Senator Little, would you like to go first with questions, or excuse me, I can?
Yes, that would be fine, thank you. And I apologise for being on teleconference. I'm trying to rectify that situation. Thank you for your submission. I'd like to go to your references to clearer guidance on terms that is associated with some of these changes. Are you able to give us some insight into the ones that you think are significantly impacting consumers, and then what you understand to be the impact on the provider in making those changes, whether they are significant or not really material for them?
Thank you, Senator. So the nature of issues that we see are things like unclear information about notice periods required to cancel a service, long notice periods for cancelling a service, unclear information more broadly around how to navigate the complexity of cancelling services. We see those issues as being relatively straightforward to provide guidance, to have guidance issued in relation to that. That we understand there are some concerns around the need to provide too much information at sign-up could confuse consumers. I think there is a really clear opportunity for industry to take a lead, particularly in the telco industry in this context, to take a lead in actually providing clear information, not onerous information, not excessive information, but clear information. The underlying principle we have here is to avoid consumers having their choices distorted or otherwise being manipulated. The provision of clear information, Senator, at sign-up is the sort of thing that we're really supporting here, so that consumers know what they're getting themselves into at the time that they sign up, as well as how to get out of those sorts of arrangements as well.
Right. You've also raised the issue of the time frame in which these changes should take effect, and you'd like to see it extended to 2028. Can you talk a little bit more about why you think that is a reasonable time frame?
Look, our overarching interest, Senator, is to make sure that we're protecting Australian telco consumers, and that really should be the priority. So as much as we can get information clearly communicated to consumers and protect further harm, that's really our overarching interest.
Look, you've also raised the issue of a staged approach to penalties, where penalties have been raised, starting with an initial penalty-free period. Is that because, given the engagement that you have with providers, that you understand that some of these are a misunderstanding or lack of clarity of information, or simply other matters? So you think an initial penalty-free period is reasonable?
What we want to see is the right outcome in the long term, and if that means that the providers have an opportunity to, for want of a better term, Senator, to get their house in order to ensure that consumers are protected in the long term, that's really what we're looking to do. As I said, we want to be able to be in a position where we stop complaints happening at all. And we're almost the office of last resort when things do go wrong. If we can work to ensure that complaints are prevented in the first place, that's our overarching goal.
Have you done any work in terms of recognising how much these changes would go to reducing the number of complaints that you're likely to have to you as the Ombudsman?
Not at this point, thank you, Senator.
Okay. Thank you, Chair. I'm fine.
Thank you. In terms of, you talked a bit about, it was useful to have the example of June in your opening statement. And that was, I think, really about the kind of issues regarding cancellation. Are they the kind of most common one of the most common issues that you see in dealing with complaints in your jurisdiction? And if you could talk about, like, perhaps the most common complaints and how this bill will address some of those issues for consumers.
Thank you, Senator. Absolutely, cancellation is where I suppose we do see the most difficulty and the most complaints coming to us out of, I suppose, sheer frustration with consumers trying to navigate the complexity of the situation. And as I mentioned in my opening statement, they are frustrated that it's wasting time. Sometimes it also involves them being, in effect, debited for another month of service or arrangement where they have tried to finalise their arrangement with their telco, and those are the sorts of things that are causing quite a bit of frustration. I suppose at the other end of the spectrum, we're also seeing challenges for consumers when they're entering arrangements. Sometimes that's in relation to website design. People are looking for clear information on pricing, on what the renewal processes are, before they've even entered an arrangement, trying to find how on earth would I cancel this if I wanted to, what are early termination charges I may be up for, those sorts of things. So I suppose it's both ends, in a way, of the relationship between a telco and a consumer, where we are seeing a level of frustration from consumers. But it's most often when they're trying to end their relationship that they're coming to us with complaints, Senator.
Mm-hmm. Thank you. And you talked just then about, obviously, the financial harms, people trying to cancel and they have to keep paying because they don't know how to cancel. There's, I think, also harms beyond the financial that this bill is going to cover.
Absolutely.
Can you talk about some of the kind of non-financial harms that you see in your work and, the importance of this bill in capturing some of those other harms?
Pardon me. It's absolutely, it's as you touched on, Senator, it's not just the financial harms. There's the time, energy, frustration. There's very much the emotional harm too that consumers experience in terms of trying to navigate the complexity of their relationship with their telco provider. I did mention digital platforms in my opening statement as well. Yeah, we do see, as I mentioned, similar issues in relation to digital platforms with website design and dark patterns. That goes to building trust and confidence more broadly broadly in the digital infrastructure. So we're talking both here at telco. It's an emotional purchase, and when you're experiencing rub or frustration in trying to navigate your way out, that absolutely influences trust and confidence in the telco sector. And I would suggest it would be similar in relation to digital platforms, albeit we don't have jurisdiction to take those complaints at the moment. But the example of June that you mentioned before, that wasn't just financial impact for her. Cancelling cards, being told to go to a store when you're unable to do so, the time and effort. Let's assume June could travel that 25 kilometres. That's time, energy and effort when you've been assured you've already done what you needed to do. And that's not something we want to be building a market around, where people are so annoyed and so frustrated they have to come to my office.
Yeah. And presumably in situations like that, they're able to sign up without going into the shop. So it's a kind of imbalance in terms of...
Yeah, and we do see examples where consumers have signed up in the shop and they want to cancel over the phone, or they've signed up online and they're told they have to cancel over the phone. The question that raises for us too is, what does that mean for retention practices? We've absolutely seen examples of consumers who feel that they've been exposed to pretty... I'm going to use the word rugged retention practices by telcos, because they're forced to call in even though they could sign up online. We don't consider that the telco-specific obligations around identification are inconsistent with being able to cancel a contract online. If you signed up online, you shouldn't have to call in. We've equally seen, Senator, examples where consumers have written in and attempted to cancel contracts, and again been told to go through a few more hoops before they're able to cancel that arrangement.
Yeah, thank you. And so I take it from I think your submission does say that you strongly support the bill, and
Absolutely.
you mentioned some other things for us to consider. So I think that's all from me, but I think Senator Little, you had a follow-up?
Thank you, yes. Look, I just wanted to get further clarity from you. You do raise in your submission there is a lack of clarity across some of the terminology that's actually used in this in order to be clear about how to deliver those better consumer protections. And you make a reference to, if that clarity is not there, it will result in unnecessary compliance costs and litigations. Can you be a bit more specific about the items in there that you believe may result in a situation where there isn't able to be resolution and it results in litigation? Which parts of the bill present those issues for you?
Senator, can I take that on notice and send in some information to you on that to provide a bit more clarity?
Thank you. That would be terrific.
Thank you.
Well,
thank you very much, Chair.
Thank you. Ms. Gabert, thank you very much. I think that is all the questions that we have. So I appreciate you joining us.
Thank you.
And we can say goodbye. Or you're very welcome to stay and listen in to continue.
Thank you. Have a lovely day.
You too. All right. So we will now welcome Ms. Chandni Gupta from the Consumer Policy Research Centre and Ms. Susan Quinn from the Consumer Action Law Centre. Hopefully we've got Ms. Gupta on her way. We'll start with Ms. Quinn in any case. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Yes, I'm Susan Quinn. I'm Assistant Director, Policy and Campaigns at the Consumer Action Law Centre.
Thank you very much, Ms. Quinn. Secretariat, is Ms. Gupta on her way?
We are just contacting the office now.
We're running a little bit early. So.
Yeah, we are a little ahead of time. I mean, if you would like to suspend, we can, or we can just start questioning Ms. Quinn, and then as soon as Ms. Gupta arrives, we can continue there. whichever you prefer, Chair.
Okay, let's kick off.
Yeah.
If that's okay with you, Ms. Quinn, do you have an opening statement?
Actually, Ms Gupta was going to make our opening statement.
Oh,
sorry to mess you around on that.
All right, no, that's
I've
right.
just
Well, why
been
don't we?
advised she's logging on now, so it should only be a few minutes. Would you like to suspend for a few seconds,
Yeah,
Chair?
okay, let's suspend until Ms. Gupta logs on. Thank you.
Thank you very much.
Are we right to go?
Yep, we're good to go. Thank you.
All right, sorry about that, everyone. We're running ahead of schedule. That never happens. I like to take the opportunity, it gives us more time to ask questions for later witnesses if we can. So anyway, I've already welcomed Ms. Quinn, and I would also like to welcome Ms. Chandni Gupta from the Consumer Policy Research Centre. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Yes, hello, I am Chandni Gupta, Deputy CEO and Digital Policy Director at Consumer Policy Research Centre.
Thank you very much for joining us. I would like to invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Chair. So the Australian Consumer Law came into place in 2011. That's 15 years ago. We can all agree that a lot has changed in that time, in particular, our relationship with products and services we use every day. Back then, buying and renting DVDs was the norm. Now we're subscribed to streaming platforms. Online shopping was a now and then activity. Today, we can have what we want delivered to our door in minutes, to our inbox in seconds. Just as our world has evolved, our laws that help to protect us need to evolve as well. I'm here as a representative of Consumer Policy Research Centre, and I'm pleased to be joined by Susan Quinn from the Consumer Action Law Centre. But it is not just the two of us. We are representing 20 consumer organisations from around Australia who have been tirelessly advocating for years to help make unfair illegal. We have one clear ask of the committee, and that is to pass the bill. In addition, we also asked the committee to include lead generation as an example of unfair conduct that could breach the general prohibition, ensure the prohibition applies to all businesses, and amend the ASIC Act so that the unfair businesses practices cannot occur in financial services. Our consumer laws have served us well to date, but they can do so much more. We have laws that make sure businesses can't lie to us, and laws that make sure businesses don't do something truly egregious. But we have nothing in between. When businesses treat consumers unfairly, it costs people their time, their money, and ultimately their well-being. And there is nothing consumers can do about it today. I will specifically share the example of deceptive and manipulative designs, also known as dark patterns. These are design features built into websites and apps we use every day to steer our choices, and often they're not in our best interest. We've all been there, trying to cancel a subscription. Before you know it, you're 6 screens deep. Or I'm sure you've seen those buttons on a website. Yes, sign me up. No, I just like paying more. That's not a choice. That's a trap with a punchline. Dark patterns have a cumulative effect. They are designed to wear us down. In these situations, it's not that a group of us are vulnerable, but businesses are exploiting vulnerabilities in all of us. Our research has found that 83% of Australians have experienced some form of negative consequences because of dark patterns. When it comes to subscriptions, 3 in 4 Australians have found it difficult to cancel a subscription, with 1 in 10 simply giving up and continuing to pay for something they no longer need or want. How is that fair? These are just some examples of the unfair practices that Australians put up with every single day. Basically, today being a consumer is as taxing as a full-time job, or at least a side hustle no one signed up for. The scales are currently tipped against consumers who are trying to find a fair deal and against businesses who are doing the right thing. This bill as a concept isn't novel nor new. Many countries around the world have had similar unfair trading prohibitions for years, and in some cases for over a century. But this reform will shift how Australians are treated by businesses. It's time to protect Australians. It's time to make unfair illegal. Thank you.
Thank you so much. I will go first to Senator Little, the Deputy Chair, for questions if she has any.
Yes, thank you. In your submission, you talk about examples that include people who have been chased by businesses to comply with a contract that they never actually have seen, and other examples. Can you tell me what you think some of the worst examples are by the current gaps in this Act, and how they would be prevented in any future Act where those clauses were given greater clarity? Because you do make reference in here to the scale of impact on individuals.
Thank you, Senator. I think one of the things that's clear at the moment is those kind of breaches, it is really unclear what the consumer's rights are at that very particular time. So where you have been pressured into signing up to something, you unfortunately can't backtrack yourself away from it. And that makes it really difficult. While this particular new bill and the update to the Act would mean that upfront, as a business, you would have to think before how you are actually treating consumers and where you are actually taking them on that journey. And at any particular time, are you distorting the environment where they particularly may have made a decision that otherwise they wouldn't, or whether they feel manipulated to sign up to something that they otherwise wouldn't have. And one of the particular things in the Act is the omission, which one of the examples that's been provided on unfair trading practices is omitting important information. And I think some of those case studies speak to where really clear, important information has not been shared with those particular customers who have then signed up to something which was nothing like what they were told originally. But I will pass it on to Ms. Quinn, as a lot of those case studies have come from Consumer Action Law Centre, if in case you'd like to add something else, what they've seen from a frontline perspective.
Sure, thanks, Senator, and thanks, Shani. Well, obviously now we're all living online more than ever. So a lot of the examples of what we see are exacerbated. Business practices are intangible. Those information power gaps and asymmetries are even exaggerated. And the manipulation that's going on can be invisible. So there are situations like, for example, online multi-level marketing or courses being sold where people are drawn in for a small introduction. They find themselves, without knowing, trapped in a subscription. We do know of one case which we included in the submission where someone was pursued for a debt of $12,000 and she was in no financial position to pay that. Another example is carnapping. So there are, cohorts of businesses, including tow truck drivers, repairers, and lawyers who are working in tandem to draw in people at really vulnerable times when they've been in a road accident, potentially traumatised as well. They don't understand what the contract is. They may never have seen it, but suddenly their car is being held hostage. They're being asked to pay an extraordinary amount of money, and they are in some cases pursued through tribunals or courts as well. Another example might be pawnbroking. Consumer Action Law Centre ran a class action successfully against a small pawnbroking business last year. Those contracts can be incredibly expensive for people. They never end. People are trapped because they can't pay the principal amount that they owe, and they just continue to pay the interest on these loans indefinitely because they're so attached to whatever the item is that they've had to give to the pawnbroker to raise a small amount of money. So you can see often it's situations where people are already very vulnerable financially or otherwise, and these businesses are clearly taking advantage of those situations.
You also raise the issue about the collection of and sharing of consumer personal information. Can you elaborate a little bit on where that is occurring and how this legislation, as currently drafted, would address those concerns or not?
So one of the ways this is occurring is through signing up for subscriptions or the use of dark patterns specifically, where things are already pre-checked, or you're going in and when you're signing up to a form or a subscription, it's already pre-checked that that information will be shared with third parties. It's those kind of elements that are built in that often you might not notice just because of the way the form has been designed or the way information is presented. Sometimes we've seen that in very small fine print, and before you know it, you've ended up, you have actually bundled that consent and said, yes, I will share that information with many others. I think one of the ways this will help, this particular bill and the update to the Act will help, is that it will actually get businesses to think about whether they are using deceptive and manipulative techniques such as dark patterns to ask for more information than is absolutely necessary. There is something there about where if you are using techniques such as what we call the data grab, where things are already pre-checked and pre-ticked, it does mean that you're ending up sharing a lot more than you need to. And given at the moment that our Privacy Act is from 1988, and we are still awaiting what that amendments will look like, having this option where regardless of what might happen with the Privacy Act going forward in its revisions, we've got these where upfront businesses have to really think about how they're asking for that information. And we've seen this more in lead generation than perhaps in other places specifically where this can become quite problematic. Susan, would you like to discuss what that looks like in lead generation?
Sure. Yeah, lead generation really exemplifies why these laws are needed, particularly the manipulative practices that are going on behind the scenes. One example is the Shield First Guardian Fund's collapse. 11,000 people have lost more than $1 billion in retirement savings through that. And ASIC told a parliamentary joint committee recently that more than $100 million had been spent by those funds on marketing, including lead generation. So what we have recommended in this joint consumer submission is to make it clear that manipulative lead generation is covered. And by manipulative lead generation, we mean those practices where basically the consumer and their data are the product that's being bought and sold, and the consumer themselves is unaware of what the arrangements are in the background. The fact that they're being manipulated because people have this information about them, and that ultimately the goal of a lead generator is to sell that person on for money. They're not selling them a product or service that they want or need. And so some of the worst examples we've seen obviously have been the Shield First Guardian collapse, but many examples of at-home solar panel sales, where lead generation has been used effectively to circumvent the unsolicited selling laws. So people get a call, or they have someone arrive at their door after filling in an online form suggesting that they can get free solar at their house paid for by the government. These practices have gone on for too long. They end up leaving people in huge debt that they can't afford. The Shield First Guardian situation is potentially even worse than that for people. And this practice really needs to be explicitly stated as being an unfair trading practice.
So what I'm hearing from what you've talked about in relation to the pre-ticked cells within the programs that people are using to view or purchase, I'm interested in understanding your preference for an opt-out clause rather than an opt-in clause for any purchases that people are making, and particularly, say, where they're on a solar panel website and they're asked whether they would support making a donation to some environmental cause.
So once again, because in this particular bill, it's dark patterns are being called out specifically, and this is one of the particular ones. It's the use of false hierarchy, where the way information is presented, and it's also the data grab dark pattern that we've coined to where things are pre-ticked. Ideally, you shouldn't be opted in for anything without having really clear information what you're signing up for. Ideally, what it should be is that instead of you having to opt out and find ways to opt out of something, you make a decision as a consumer what you're opting into. So even for a donation where that's pre-ticked, it should be a consumer's choice whether they go ahead to do that. And that's the same with, we've seen in the cases of where someone has bought a home appliance, for example, and it has automatically, the website has automatically signed them up to an extended warranty, yet it appears that you've only bought one product until you get to that final checkout where it says there's two products, and you've also been signed up to some form of subscription membership program as well. These are the kind of business practices that we would like to see the end of, and we believe this particular bill that's being proposed will do that.
What about those particular practices where you start engaging with a system and you're actually almost finding it impossible to log out or exit that system?
Yes. So one thing that's really exciting about this particular bill is the provisions that have been built in for subscription services specifically. And one of the things we have noticed, as I mentioned in my opening statement as well, it is by far one of the most difficult things that online most customers have to deal with. 3 in 4 Australians have had some form of difficulty trying to cancel out of a subscription or trying to cancel out of a system that they no longer need or want. And we've seen where those practices are really quite upfront, quite blatantly problematic, where you will see the cancellation button is in like a really grey font, in a tiny font at the end of a screen, or it's really difficult to find, or you keep going through different loops where you'll be asked, you'll find the cancellation button, but then you'll be asked, are you sure? Which is a tactic known as confirm shaming, and it will say things like you will lose all your benefits, you won't be part of this community, all of these additional pressures that are then put on the consumer. And then on top of that, we've also noticed where in some of these services, we've got where they ask you, why are you cancelling? And we have found that it does not matter what you pick as the answer or your response. It will automatically go to the next screen, which will be, let's give you a great deal for the next month. And you get a very small reward. It could just be 50% off for the next month's subscription, only for it to bump up to a premium subscription after that. So what we're seeing is with this particular bill, the amendments that are being proposed, it hopefully will be much easier for consumers to get out of services they no longer need or want.
Okay. You also make references to the bill should not allow for any carve-outs of any sectors. Can you elaborate a little bit on why that's important from your perspective?
Yes, of course. What we've seen in our work, and also when we've spoken to experts overseas in jurisdictions where there is an unfair trading prohibition or a similar law, what we've found is the most effective ones are those that apply whole of economy wide and are tech neutral, because it means that as practices evolve, as our world evolves online or otherwise, the law is broad enough and general enough to keep pace with that. And one of the particular things is if we only have a particular sector that is held accountable, what we will see is that it's very difficult then for the consumer, and often it will be on the consumer to work out whether that particular business is whether that particular business actually is to be held accountable under this law or not. So what we'd like to see that it applies across the economy wide, regardless of the scale and the size of your business, and also regardless of what you as a business are selling. So in particular, one of the ones we have raised is for financial services. At the moment, the unfair trading prohibition, the way it's been proposed, doesn't apply to financial services. But we have seen where if this goes ahead the way it currently does, it will mean that there will be a gap. It means that other businesses will have to make sure that practices such as dark patterns and subscription traps and all of those, they will have to adhere to those, but a financial services operator may not need to. And one particular example we've seen is in the case of investment apps, which are now using a lot of these dark patterns tactics to in their apps. And this is where we'll see where it will then fall on the consumer as an individual to work out whether a business is obligated under the law or not.
Okay. We've heard from the Ombudsman earlier about a transition period that takes us to 2027, but your submission talks about immediate proportional penalties. Why do you think it's unreasonable to allow for a transition period?
So what we're saying is as soon as possible. We feel Australians have waited long enough for this, and those businesses who are doing the right thing you shouldn't have to worry at all, basically. And so this is an opportunity to lift everyone up as soon as possible, and for Australians to start experiencing consumer rights the way many other jurisdictions and consumers in those jurisdictions have been taken for granted for years. It's our recommendation. We're basically saying as soon as possible.
I also wanted to ask about regulation. Your submission talks about the need for a well-resourced federal and state regulators. Would you see what impact do you think that these changes would have on less regulation that's actually required by a third party and more self-regulation by not just the businesses but also protections for the consumers?
So I think we've seen how self-regulation has worked in this space, and subscription traps are a classic example of this. We saw big companies do it, and now we just see that that model replicated across any kind of subscription service that we see today. So we do know self-regulation is probably not something that's going to work in this space. And we've also seen where in other jurisdictions where there's an unfair trading prohibition, they've then looked at how they uplift a lot their regulators overall. I think this will be a matter of seeing where we can help resource regulators so they're able to take up big cases like big tech and a lot of those international organisations that obviously operate here in Australia. We just need to ensure that they're proportionally resourced to be able to do some of that work so that those businesses who are breaking the law are held accountable proportionately.
Thank you. Thank you, Chair. I'm fine.
Thank you. Some stakeholders in their submissions have argued that there isn't any gaps in consumer law, but in your work and some of the things you've talked about clearly identify that there are. Can you talk about that discrepancy and I guess perhaps informed by the experience of the work that you do, where the gaps are that you see that need to be most dealt with?
So currently there's two specific laws that we have within our consumer rights space. One is the misleading and deceptive conduct, and one is unconscionable conduct. Both of them have a very, very high threshold, and we've seen that play out in courts where we have had judges say, yes, this is extremely unfair, but it isn't illegal. And that's where the gap is. So the threshold is so high that some of these other very egregious practices and practices that do actually cause a lot of consumer harm aren't quite neatly captured in those two particular laws.
Okay, thank you. And I think you've talked about this a little bit, but in terms of a kind of principles-based approach to prohibition, can you talk a bit more about, why this kind of approach is your preferred approach, particularly around dark patterns manipulation, rather than kind of, providing examples and having lists about the sorts of things that we want to see outlawed?
So as we've seen over the last 15 years, so much has changed. Next 15 years, things will evolve even further. We actually don't know how our online world will evolve over the next period. So what you would like to see and what we'd like to see is that the laws that we have in place are tech neutral, they're principle based, and it gives the flexibility to a regulator to take action based on how products and services evolve and how businesses evolve in their practices. I'll give you the example of the US. The US has had an unfair trading prohibition equivalent since the 1930s. They've been able to use that law to take action on dark patterns against very large businesses such as Fortnite. I think they charged over $245 million in fines. And it's because they've not had to then keep thinking, is there a gap here? Does this neatly fit? Because it's a principles-based approach, it means that they're able to go, actually, this is unfair and this is causing consumer harm, therefore we are able to regulate.
Yeah. And so in your view, these proposed changes, are they similar to the 1930s US example that you gave, such that they would be future-proofed in the same way?
By having that general definition that's really upfront, that general statement that businesses can't treat consumers unfairly, that particular statement up front is what actually specifically helps, because by having that general statement, you're able to then capture all sorts of activities. And now as we see, as AI evolves over time, our use of AI evolves over time, there will be practices that will come forth that we aren't aware of as yet, that we would then hopefully be able to capture through this particular law, because we'd be able to put that lens of, is a person in commerce or trade acting in unfair trading practices?
Mm-hmm. I think I know the answer to this question, but I'll ask it anyway. Thinking about that general prohibition concept, we've heard some stakeholders talk about limiting the general prohibition in various ways, so particularly excluding certain sectors or restricting it to digital environments only. What do you think about that?
As we've said, the most efficient unfair trading prohibitions around the world are whole of economy wide. It shouldn't be on an individual to work out whether that business is obligated under that law. It should be, I've been treated unfairly, I need help, and I need to be compensated accordingly.
Yeah, so it should be based on bad behaviour as opposed to what setting you were treated badly in.
Exactly. And it means that at the moment, it's really difficult to tell which businesses are doing the right things and who aren't. And to be able to have a level playing field that you all need to be treating consumers with care and respect and to treat them fairly, it's actually not asking very much. And those businesses who are already doing the right thing, and there are so many of them in Australia, they have nothing to worry about because they're already meeting obligations under this law.
Mm-hmm. Well, that is a nice segue because I did want to ask you about the impact on businesses. There's also been concerns raised about the regulatory burden on business. So, how do you think we should be thinking as a committee about balancing protection of consumers, but also compliance costs on businesses to, when we're thinking about how we will reform harmful practices in this way?
So when I think about businesses, I know at the moment you're also consulting on small businesses and them having the protection. That is something that is so key to ensure, because there are subscription products and services that aren't just used by individuals, but they're also used by small businesses. So we have, for example, the example of Adobe. Adobe has some questionable subscription practices. We've actually raised concerns and have raised a complaint with the ACCC about 3 years ago, where we were showing exactly, while they're breaking some specific laws at the moment, but there are some places where they're treating consumers unfairly, and those products and services would be bought by small businesses as well. So what we'd really like to see is that small businesses are also protected by this, not just individual consumers. So when they are buying off-the-shelf products, which many of them will, that they can also have the confidence that they're going to be treated with care and respect.
Mm-hmm. Yeah. And maybe if I've just one final question before I think we have to let you go. In your discussion earlier, you talked about lead generation. So, and I think, the kind of inclusion of an economy-wide approach, including financial services, but particularly around lead generation. And, the example you gave around Shield First Guardian. I understand that there's consultation processes looking at this through including the ACCC designated complaints processes. And I just wanted, I wanted your thoughts. Firstly, are you involved in those consultations to kind of feed your views in, given, the example that you gave earlier, particularly around Shield First Guardian, and then, a view about where is the most appropriate vehicle to address that issue in particular, whether it is these laws or through this other process that's going on. Interested in your thoughts on that.
Yeah, thanks, Senator. So yes, we're involved in the processes underway at the moment in close contact with the ACCC. Their work on lead generation was sparked by the designated complaint that Consumer Action made in relation to unsolicited selling, and as I mentioned, where lead generation is being used to circumvent the laws in place there. We're also, or have recently made a submission to Treasury as part of their super reform packages and curbing lead generation activity as part of that. In our view, there are some really good options in Treasury's proposals which would shut down certain activity, for example, unlicensed communication about superannuation, advertising without a licence, those types of things, hawking financial services. But what's missing, I guess, is this general prohibition on the conduct that we're seeing. So there could still be gaps in those proposals that are sitting there with Treasury and the ACCC at the moment because they're more focused on business structures, practices, processes. What we're talking about here is the consumer experience, the manipulation, the unreasonable distortion of the environment that somebody is in. And this is the measure, the unfair trading practices prohibition, that addresses what is common among all of those business practices and structures. Chandi did also mention the importance of this being economy-wide, and for the Shield and First Guardian example, you had licensed financial advisors and unlicensed lead generation companies working very closely together, and it was the combination of that conduct that was causing people to end up in those horrendous situations that they're now in. So really, really critical that this unfair trading prohibition is an overlay on all of the other reforms that are specifically targeting some of those business practices.
Okay. And how would that work, do you think?
It effectively would just close loopholes, is our view. So we have seen, for example, lead generation being used to get through loopholes. In fact, the businesses are often designed in that way. And so what this prohibition does is say, irrespective of how you structure your business or your transactions, the conduct that you're engaging in is prohibited. And again, that's why it's important that it's market-wide. What it will also do is where there are good businesses of any size operating fairly, it's going to clean up the market, enhance competition for those businesses that are already doing the right thing.
Mm-hmm. Thank you. And I was thinking we're finishing at 10:40, not 10:50. So I might ask one more quick one, and then if Senator Little's got any last ones before we let you go. There's been a suggestion from some stakeholders that we don't need Section 48A. And I was just wondering if you could talk about the harms that led to its inclusion, particularly in relation to drip pricing and hidden fees, and why the current Section 48 isn't sufficient. And I think you did cover some of this in your opening statement, but I guess if there's anything else that you wanted to add to that.
What we've noticed is it's becoming harder and harder in particular areas to really see what an upfront cost is. And you as a consumer should be able to know what you're paying before you go down many, many screens and to make a purchase. And it's the overlay of dark patterns where information is shown in different ways. You might be put in a virtual queue for a concert ticket. All of those things then create this unnecessary burden to purchase because you've then committed to all this time and effort only to go to that final screen and then see exactly how much something costs. 15 years ago, you probably would have never queued for something without actually knowing how much something costs. Yet last week, we had the Korean pop band's tickets open up, BTS, their concert tickets open up, and there was no information on pricing upfront. Consumers had to wait in a virtual queue known as the waiting room, and then after they've gone through that, they've actually already bought a particular membership program to be able to access the tickets early. So they've already made a financial investment. Then they've sat in the virtual queue. And it's only after that that they got to see the price. They also don't know if they're being sold the same ticket at the same price as others. We've also seen studies that have been done in the US through a ticketing company where basically we had where we saw a ticketing company split millions of their customers in half. Half of the customers got shown the price upfront, the full total price upfront, and half of the customers saw a base price with things added on along the way during the transaction. And what they found is the people who saw the base price and then added on and then saw the add-ons, they paid more for their tickets and they were more likely to complete the purchase. Businesses know exactly what they're doing when they are hiding what the total cost is. So it's actually a really important feature that's been added into this particular proposed amendment.
Thank you. Thank you very much. Senator Little, did you have anything else before we let these people go?
Right. Yeah, I just wanted to ask, in terms of the gaps that are currently identified in consumer law that these changes would seek to close, are you confident, because we have heard in earlier evidence that the language in the current legislation is a little vague, and I'm just interested in if the consequence of that is increased complaints, increased litigation, what the impact of that might be on consumers?
It's probably not that it's vague, but it's more that it's broad and principle based. So instead of it being really prescribed, it's broadly saying that you can't be practicing in unfair trading practices. And I think that's a really key feature. And as we've said before, misleading and deceptive conduct, unconscionable conduct, both have very, very high thresholds. And so we've seen cases, there was the Medibank case a few years ago, which the judge mentioned, yes, omitting information about key parts of a particular product that it was selling was unfair, but it wasn't illegal. The fact that people didn't know that there was actually limits being put on some of their in-hospital services, it's those kind of actions that we will see that this particular bill will help mitigate. There are cases that we've seen where so many times it has just not met the threshold of misleading and deceptive conduct or unconscionable conduct. Yet you can see that the consumer harm was there.
Okay, thank you. Thank you, Chair.
Thank you. Well, thank you very much, Ms Gupta and Ms Quinn, for your evidence today. The committee will now suspend for a short break. We're running a little early, so we will return at 11:05. Thank you. Professor Jeannie Patterson. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
I'm Jeannie Patterson and I'm a Professor of Law at the University of Melbourne.
Thank you very much for joining us today, Professor Patterson. I invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you. Well, the government should be commended for seeking to tackle the problems of the unfair treatment of consumers, which has a new urgency in the digital age. This bill seeks to address unethical techniques related to dark patterns that distort consumer choice by exploiting cognitive biases in a way that amount to, use economic terms, sludge, not nudge, consumer decision-making. The capacity to manipulate or distort consumer decision-making to their detriment is only amplified in the age of AI and social media. Are there improvements to the provisions? Yes. The rule-based aspects of the regime should be clear and well targeted. In particular, the subscription track provisions should allow consumers to access clear information and unsubscribe in a straightforward manner. And I think that some of the examples of unfair practices could be better targeted. Overall, though, I'm in support of the provisions, and I finish by noting that legitimate marketing influences or persuades consumers to good outcomes. It does not manipulate or distort consumers to the benefit of the seller. Thank you.
Thank you very much. Senator Little and Deputy Chair, do you have questions?
I do, thank you. Thank you very much, Professor Patterson, for your submission. I'm wanting to focus on, I know you generally agree with the proposition. You've made that clear in your submission. I'm wanting to explore a little bit more your focus on vulnerable persons, in this case children, and how you see they would be protected by this change to the legislation.
Thank you. One of the key examples currently of practices that are targeted to children or exploit children's decision-making relates to online gaming. And I'm sure all of the committee would be aware of the dangers and addictive tendencies of online gaming, but also sometimes educational and community building advantages. What we know from previous examples of online games is that in the height of the game, the sound and the noise is designed to keep children playing, to keep children engaged, and also to make online and in-game purchases to their detriment. There's been findings against a number of the gaming companies in the in the EU and in the US. And I note that researchers at Deakin University recently identified the same kinds of addictive and manipulative practices in games available in Australia. So that's games like Fortnite and the like.
Can I ask, with respect, you've been talking about transactions. What about where there is no consideration in exchange for a particular action by the person who's actually in a game?
You mean
where the actual purchase is not necessarily the end game? The behaviour may be.
That's right. So there's two ways that consumers may be paying for things that happen online, and that is with their data or with their with money. So in some aspects of online gaming, credit card that was entered at the outset to allow access to the game can be reused for on-game purchases, which aren't always necessarily clearly flagged as on-game purchases. They're also often have an element of gambling because the user doesn't know what they're buying. It itself is a game of what you obtain. So that's the for cost or for a price purchases. But of course, a lot of online interfaces are relying on either sustaining engagement. The longer the game is played, the better the benefit to the provider of the game. And the same is true for online chatbots as well. The more you play, the more you talk, the more the advertising revenue that procures to the provider of those services. And of course, users are paying with their data. So information is being collected about their proclivities, their interests, their responses to online interfaces. So although when users of games and indeed online chatbots are not always paying a price in the sense of monetary consideration, often they're paying by being experiments or by providing data. Does that answer your question, Senator?
Yes. Do you see that this legislation actually covers the potential for addressing those particular instances you've just given?
I think I think this is an interesting question, and I would love if the legislation made a reference to children and the greater protection of children. I also think that the legislation complements the new changes, the new Children's Privacy Code, but I do think that online interfaces that are designed to trick people into playing longer, handing over money, or engaging in data sharing practices are caught by this legislation because they are manipulating the choice or distorting the information environment.
Right. Thank you. How do you think we'd be able to measure, if this legislation were in place, what would we see as a measure of success?
Well, I've been in discussion with my colleagues at the Faculty of Economics, and they have a decision-making lab, which is the Mind and Brain Lab, which combines computer scientists, psychologists and economists who measure consumers' responses to online interfaces, and indeed have a behavioural unit that's very interested in online gaming and gambling. So I think that it would be possible to test online interfaces, and in fact I think that will be necessary to establish where consumers or young consumers are manipulated, and then it is possible to audit sort of key websites to see whether there are changes in their design interfaces and the effect of that on consumer decision making. I think it's really important. Actually, this provision is premised on economic research about how consumers make decisions and how decisions can be manipulated. And I'll add again, particularly for very young children or children that are still forming decision-making capacity and the like. So this legislation is premised on research about consumer decision-making and how that can be manipulated. And I think it's very important that both the impact and the changes are measured in an empirical way, but there is research capable of doing that.
Thank you. Thank you, Chair.
Thank you. Professor, I think in your submission you note that the bill responds to harms not reliably captured by existing Australian consumer law protections. Can you talk a bit about how your research demonstrates clear and persistent gaps in the current law, and what some examples of those gaps might be? I don't know if you were listening earlier, I talked to the Consumer Action Law Centre and the policy people about this too, but just wondered if you had the same view and kind of what your research shows.
Well, I've been working in the field of consumer protection law for a very long time, since the last century, in fact. And the prohibition on misleading conduct in particular does a lot of work. The recent ACCC and Coles decision indicates the capacity of that provision to, in fact, find misleading conduct where consumers aren't given the full story or aren't given full information. So that provision is incredibly powerful. But what it doesn't deal with is this use of particularly online interfaces that respond to cognitive biases on the part of consumers. It's useful to think of two examples from overseas decisions which have found this. One of that is the fortnight decision that I mentioned about the manipulation of decisions about the purchase of online games, where the very design of the online platform was designed to make it very difficult for players, particularly young players, to realise they were making purchases as opposed to progressing through the game. So different kinds of buttons placed in different positions at different times counterintuitive colours. So instead of having green for go, red for stop, they'll swap the colours. So that's one example. The other example would be Amazon Prime, where consumers signed up for an Amazon Prime subscription over a period of time when they were making purchases online. And again, they were asked if they would like free delivery. They had to click out if they didn't want free delivery, but there was very fine small print to say they were signing up to Amazon's subscription service. Now, in both of those examples, it's not really captured by misleading conduct because actually all the information is there. It's not an example where information is missing or the information is wrong. The information's all there, but the flashing lights, the use of colours, the use of sound, the use of the adrenaline of making a purchase or playing a game is what distorts decision-making and really requires much clearer and interfaces and what we would call friction in the purchasing process.
Thank you.
I should also add the other issue will be, of course, personalised pricing. So increasingly we're seeing advertising online is hyper-personalised because of information captured and the ability to use AI and other provisions to actually change the format of advertising in real time to respond to the behaviour of the consumer and their degree of engagement. And again, that's not captured by misleading conduct, because misleading conduct is information that's not true or is creating a false impression. Well, what we're doing here, as I've said, is the use of the knowledge about the consumer and the interface to confuse or, as I've said, manipulate to their detriment.
Yeah. So there's obviously, like what you've described there is, I guess, manipulative in terms of flashing lights and, you know, pressure in different ways. There's also ordinary legitimate commercial persuasion. So how, like, do you think that the bill appropriately targets conduct that distorts decision-making without impacting on ordinary legitimate commercial persuasion?
Yes, I do. And I think we can go back to economic theory here. So I'm not sure if any of you are economists. I'm not an economist, so this is my version. So in economic theory, three markets are premised on free and informed consent. People should be free of coercion, and they should be informed or given the salient information that they require, noting consumers don't usually read information at the point of purchase. And marketing is aimed at influencing consumers, tantalising their interest, but it shouldn't be manipulating their decision-making. It shouldn't be crossing that line where the decision is no longer free and informed. And actually that line is very well recognised in economic theory. Most marketers are actually trained in faculties of economics in marketing departments, and marketing departments do understand the difference between informing and influencing and manipulating and distorting. And remember, that's to the detriment of consumers. So in public health, we often use nudges to encourage people to make good decisions. So, for example, you put the salad at the front and the fatty food at the back of the cafeteria. And there's various ways of encouraging people, for example, to donate organs or blood as well, which relies on cognitive biases. So opt into organ donation, opt in. You have to opt out of organ donation. You have to opt out of, there's various other strategies to encourage blood donation. So sometimes encouraging people towards decisions is, we all probably consider it legitimate. That's called nudging people to welfare-enhancing decisions. Sludging is where cognitive bias is used to influence people to decisions that are not welfare-enhancing. And this bill doesn't just require manipulation and distortion, which I would say would go beyond the line of legitimate marketing, but also requires detriment to the consumer. So if the consumer is influenced to make a decision, ends up with the best possible product, then that's not going to be to the detriment of the consumer. Yeah. So there's a built-in protection in the provisions, even to the extent that people might be worried about that line.
Yeah, okay, thank you. We haven't explored this so much this morning around comparisons with overseas. So I was wondering maybe if you could talk a bit about if we align ourselves with overseas jurisdictions, like does this bill do that? And then, what are the benefits of that, I guess, in terms of does it help us avoid becoming a safe haven for these sorts of practices? Or are there other benefits you see?
Well, I think it's important to realise that what happens with large multinational companies, and no doubt you know this, is they divide the world up into different regions, so that we're in Asia or Southeast Asia Pacific, there's Europe, there's South America and so on. Now, research done by myself and other people notes that before penalties were imposed on unfair contract terms, we actually had the Southeast Asia unfair contract terms, contract terms, not the European contract terms where unfair terms were prohibited. So companies do distinguish or discriminate between jurisdictions in terms of their marketing. So other jurisdictions are introducing various forms, or already have various forms of prohibition against unfair practices that sort of target this idea of sludging or manipulating behavioural biases to the detriment of consumers. Europe has it in two places. They have it in their Unfair Trading Directive, but they also have it in their Digital Services Act. And in fact, the Digital Services Act is probably the provision that is closest to what we are suggesting. And although I'm just going to make a comment that I am a big fan of really simple drafting, and I do think that in some places this bill is rather wordy. But that's probably not your question. If you would like, I can read out the prohibition in place under the Digital Services Act in the EU. Would you like me to do that, or not really at this point?
Maybe you could provide it on notice. That would be helpful, because then we've got a record of it. Yeah, thank you.
That would probably be more useful. I also note that the US has used a provision that it has in its Federal Trade Commission Act, which is a general prohibition on unfair acts or practices affecting commerce, and that requires conduct that effectively distorts the decision-making of the consumer as well. So both the US and the EU have these provisions. The UK has them in some form as well. And the US and the EU also have quite targeted provisions on subscription traps, which is, of course, the other piece of the legislation. Now, we use slightly different wording because the framework of our Australian consumer law is a bit different from either of those jurisdictions. But I really would commend the Digital Services Act to your attention, because it's really clear and very crisp and picks up on that concern about manipulative practices from personalised pricing.
Mm-hmm. Thank you. That we've had a bit of a discussion about this morning around the concept of a general prohibition, as opposed to more specific granularity. Do you have a view about a general prohibition in terms of Australian consumer law keeping pace with modern forms of consumer harm and future proofing?
Yes, the Australian consumer law is by and large a very beautifully drafted piece of legislation, because it uses a combination of principles-based prohibitions, don't engage in misleading conduct, with then more rule-based explanation of particularly problematic conduct. So, for example, there are specific rules about pyramid trading schemes, which arguably are misleading, but because they're so insidious, we have a particular provision about them. I like that this provision is designed as principles-based regulation. It's very similar to the unfair contract terms legislation, and there's a prohibition with 3 elements that have to be considered. In this case, the detriment element is the one that really protects marketing, as well as the sort of moral odiousness that comes with ideas of manipulate and distort, which are an affront to the autonomy of consumers. So I like that. I do also like that it is accompanied by what should be a grey list of prohibited practices. I think some of the submissions have mentioned that they would like more granularity in the grey list, and I think there's something to be said for that. I think that the first 2 elements of the grey list are pretty vague, actually. The last 2 are clearer. I think it is useful to have a little bit of granularity in the grey list. That's what's true of the unfair terms provisions. And strikes that balance between adaptivity, because you have the general provision, and clarity, because you have that grey list that's just a bit more clear of the type of practices that are being targeted. And there are examples of grey lists in California, for example, and to some extent in that EU provision I mentioned to you.
Thank you. Do you have any views on the expansion of protections to small business and or mirroring protections in the ASIC Act around this?
The ASIC Act is I'll start with the ASIC Act, if I may. The ASIC Act is interesting because by and large it mirrors the ACL, Australian Consumer Law protections. The difference is that there's already a general provision in the ASIC Act on conduct from licensing, let me rephrase this. There's an obligation in the licensing provisions to provide the services in a manner that is efficient, honest and fair. Now, to some extent, that probably covers similar ground. I would probably prefer this provision also to be in the ASIC Act, notwithstanding, because I think it's good signalling about the type of conduct that's expected. And obviously, financial services are one that have particular impact on people's lives. And we already know that on social media, there's a lot of interesting conduct, and I'm not even counting the scams conduct. So probably my preference would be to keep that symmetry. In terms of the expansion to small business, Australia is quite unique. Australia is probably the only country that has extensive protections for small businesses in the way that we do. We've got unconscionable conduct, misleading conduct apply to all conduct in trade or commerce. Unfair terms also apply to small businesses. I guess if unfair terms apply to small businesses, then there is a case for applying this provision to small businesses. I tend to think that the type of conduct we're talking about is very much targeted at individuals. It's behavioural and cognitive biases, which perhaps affects mum and dad type businesses, but doesn't apply with quite the same force, I think, to businesses that are unlikely to be targeted personally by online advertising. So I think the case isn't as strong. I do think, however, that we need the reforms proposed for consumer guarantees for small businesses, because certainly franchisees and car dealers are subject to a lot of really aggressive one-sided conduct in the market. I tend to think that protection might be provided by the consumer guarantees. As I said, though, I don't have a strong view on that point.
Mm-hmm. Thank you. Deputy Chair, do you have any additional questions?
Yes, I'm sorry, I might need to put this one on notice because I did miss this in my earlier review of this, but the explanatory memorandum refers to the bill raising human rights issues. There's a reference here to the Statement of Capability with Human Rights in Chapter 2. I'm wondering, have you had a chance to have a look at that, Professor?
I have not considered that aspect, other than in regard to the fact that attempts to manipulate people and distort people's autonomy is contrary to their rights to be treated as autonomous individuals and their decision-making agency to be supported. But I can have a look at that and respond if you wish.
Would you do that, please? That would be appreciated. Thank you. Thank you. Thank you, Chair.
Thank you. Thank you so much, Professor. I think that concludes our questions for you. So we can move on a little early now to our last witness. I think they are here. And they are, so I will welcome representatives from the Australian Competition and Consumer Commission. And I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and capacity in which you appear today?
Good morning, Chair and committee members. My name is Katrina Lowe. I am Deputy Chair of the ACCC and appear in that capacity today. I'm joined by my colleague, Lauren White, who is our Executive General Manager of our Consumer and Fair Trading Division.
Thank you very much. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you very much, Chair. I would like to take the opportunity to make a short opening statement and begin by saying that the ACCC strongly supports the reforms that are proposed in this bill, namely the general unfair trading practices prohibition, the provisions to make subscriptions clearer and importantly easier to cancel, and the requirement for businesses to prominently disclose transaction-based fees. Through our work over many years now, we have observed both under-regulated or unregulated unfair trading practices that cause significant detriment to both consumers and small businesses in both the online and also the offline environment. Markets and products have subsequently become increasingly complex for consumers and to a degree for small businesses to engage with. And we have found through our compliance and enforcement work that the current prohibitions in the Australian consumer law have been insufficient to protect consumers and small businesses from harms that are significant. Unfair trading practices can also disproportionately affect and impact consumers experiencing vulnerability or disadvantage. We consider that a prohibition on unfair trading will be an important safety net to protect consumers and small businesses from harm, but we also consider an unfair trading prohibition is an important microeconomic reform that will set improved standards for business behaviour and thereby promote better conduct in the marketplace. In short, that it's good for consumers, including small businesses, and good for competition. In addition to our strong support for the reforms in the bill, we also consider that there is a need for an unfair trading practices prohibition in the Australian Securities and Investments Commission Act 2001 to cover financial products and services and ensure that effective protections from harm and an improved standard of business conduct occurs across the economy consistently. The lack of harmonisation between the Australian consumer law and the ASIC Act on unfair trading poses the risk that consumers and small businesses will be left exposed to harm and markets functioning suboptimally. Inconsistent protections across the Australian consumer law and ASIC Act lead to regulatory gaps that unscrupulous providers can take advantage of, or businesses can simply fail to fall within by happenstance and thereby escape regulation. Lastly, we note that it's not always clear at first blush whether a particular product or service is a financial product or service or falls under the general law. And some products and services, of course, are a blend of financial and non-financial elements, and therefore an inconsistent policy approach depending on whether or not something is or is not a financial product or service is likely to increase the regulatory and compliance burden and inhibit effective action against unfair practices where they exist. Thank you.
Thank you very much. I will go to the Deputy Chair for questions first.
Thank you, and thank you, Deputy Chair, for that submission. I'd like to ask about your reference to the consumer to business part of that and your view particularly on protections for business to business in relation to legislation.
Thank you for the question, Senator. And as my opening remarks suggest, it is absolutely the case that in addition to harm that we have observed in the marketplace for consumers, we have also seen examples in relation to small business in particular where they may be seeking to negotiate with larger businesses. So in our submission, some of the examples that we have pointed to are, for example, where a large business, particularly those with monopoly power, might be using their superior bargaining power to pressure small suppliers to amend contract provisions in an ongoing and enduring contract in a way that results in worse outcomes for those suppliers, such as lower prices. Those examples and encountered those examples in our perishable agricultural goods inquiry and noted those in the report, and also in our wine grapes market study in 2019.
The bill says there is, or the explanatory memorandum refers to there being no or minimal financial impact on these changes. Would that be your view, or would there be an impact not necessarily on from a financial perspective, but on a resource perspective for even, say, the ACCC?
Thank you, Senator. We certainly accept that with the introduction of new law, and indeed we expect with the introduction of new law that businesses that are covered by the law will take steps to ensure that they're able to comply, and that there are likely to be costs, including time, for those activities. However, we also note and do agree with the examination of these questions in the regulatory impact documentation that notes that the benefits of the legislation significantly outweigh those costs, and we welcome the current consultation in relation to the extension of these prohibitions to small businesses, because of course it means that specifically small businesses will be able to benefit from the same sorts of protections. However, they will also benefit from the current law as framed through those improvements to market-based conduct that we have referenced. One of the other reasons that we are strong supporters of these laws is that they're competition enhancing. They mean that businesses that are competing fairly on the merits will not be crowded out by businesses that might be competing through manipulative or unfair conduct. So the benefit flows to those honest businesses and improves market conduct generally. I should also add that the ACCC, I beg your pardon, Senator.
No, please keep going.
I was simply going to add, Senator, that we have been provided with a modest amount of funding to assist with education and implementation of the laws should and when they pass the Parliament. And as part of that approach, of course, we will be focused on education and the development of resources that will assist all businesses, but particularly small businesses, to ensure that they're able to comply with the law.
Yeah. Thank you for such a comprehensive submission. You've even made some suggestions for changes, minor changes to the legislation. Can you talk us through particularly those amendments that you have recommended in there? Because we have heard early evidence that this legislation as currently presented would benefit from some further clarity to remove any ambiguity for people trying to navigate it and comply with it.
Thank you, Senator. I should say that we are supportive of the framing of the broad principle as has been ultimately put forward in the law. We do think that the removal of the words unreasonably in relation to manipulators an important element of the law as framed. The sorts of amendments that we have advocated for, Senator, really are the addition of additional grey list examples to really give further guidance and explanation as to the sorts of conduct that will be covered by that broad general prohibition. I should say that we do consider that these examples are covered by the general prohibition, but we consider that they are useful examples in relation to the sorts of conduct that the prohibition does cover, but also give guidance as to the sorts of practices we have already observed in the marketplace and may be giving perhaps early attention to from a compliance and enforcement perspective. So some of the examples of the sorts of practices we've included are using influence to cause a consumer to agree to vary a contract that would cause the consumer detriment, financial or otherwise, or to pay a sum of money that the person is not contractually entitled to receive. Another example we've pointed to is failing to provide an accessible and effective contact point for customer service support and failing to take reasonable steps to prevent the sale or promotion of unsafe goods on a platform or website. Or indeed unreasonably inhibiting access to or enjoyment of a product already purchased. So that is picking up the notion of, for example, making software changes to a product that in effect diminishes the functionality or performance of that product without providing a recourse or remedy to the consumer. There's some of the examples that we have observed in our practice.
Thank you. You kind of touched on it, but I'm just wanting to understand this a bit more. Are you making a reference to those businesses that are actually engaging with consumers, actually having a viable, accessible complaints process as well? Is that potentially missing from the legislation?
We certainly consider that it's important that businesses have channels that are available for consumers to make contact and to easily make contact when they experience difficulties with goods and services. We do, as a matter of general principle, support the broad principles-based framing of the prohibition. We think the combination of the broad prohibition and then a grey list with some examples, but very importantly, they are examples. They are not an exclusive list of what breaches the prohibition. We think that really gives us the best of both worlds. We have obviously, with the existing Australian Consumer Law and the Trade Practices Act, before it had considerable experience with broad principle-based prohibitions, and we do consider that they provide very important longevity that can be absent where more prescriptive rules are written. They can easily become out of date, and they can also be more easily avoided by bad actors that are seeking to structure themselves to get around the law. So we really do think that that combination of the general principle-based prohibition with the grey list really does give this law both the flexibility but also clarity that is a helpful balance. But of course, we would be happy to see some of those additional examples in the grey list to give that further assistance.
Mm-hmm. You also make reference to potential for the provision of the ability for the courts to make adverse publicity orders. What effect do you think that would have on improving outcomes for consumers?
Thank you, Senator. The provision for adverse publicity orders is a notion that already exists in the law, and we certainly do consider that in addition to penalties and penalties that are more than a cost of doing business, drawing attention to poor conduct by those who infringe the law is a very, very important aspect of deterrence, not only specifically for the business, but also for other businesses, so that there is a more general awareness both of how to comply with the law, what crosses the line and doesn't comply, and also provides that public awareness of both the conduct and also what is to be avoided. I'll just check whether my colleague would like to add anything to my answer.
Thank you, Katrina. Just to add that they are a very important tool. It's in a way, what it does is require a company to state publicly the conduct for which they have that they have breached the law in relation to, and that's very powerful both in holding them to account but sending a very clear message to businesses that specific type of conduct will not be tolerated.
Thank you. Now, you mentioned before about the framing of the legislation, and we've heard some evidence about people liking the broadness of the new prohibition on unfair trading practices. But do you see any risk for, given we've just been talking about the courts, greater legal uncertainty for businesses in terms of what they are able to and are not able to do?
Thank you, Senator. Certainly the courts will have an important role to play in articulating, as the laws come into being, the boundaries of the prohibition as it's framed. However, we do consider that the principles-based drafting as it stands emphasises really the fundamental objectives of the law, which is that businesses are honest and fair with their customers, and businesses that are to engage in the marketplace in that way are at very low risk of breaching the provisions of this law. Secondly, as I've mentioned, there will be, or there is proposed to be, a period of 12 months before the law comes into effect, and we intend to utilise that period, as I've mentioned, to work with businesses and their representatives in relation to compliance with the law and to produce guidance that will assist businesses to comply. Lastly, I would say that that role of the court and indeed our role as a regulator to bring matters before the court that will help clarify the boundaries of law is a very important part of the process. It is necessary in order to get the benefits of the flexibility and the longevity that a principles-based provision provides. The law against misleading and deceptive conduct really has stood unchanged in its original framing for 50 years, despite the changes that we have seen occur, dramatic changes that we've seen occur in our marketplaces over that period of time, and that is the benefit of a principles-based law.
Right. So you've also mentioned that you'd like to see the legislation enhanced to also provide protections, not just at the point of transaction, but also in the pre and the post-purchase part of any engagement that somebody would have with a provider or supplier.
That's exactly correct, Senator. We certainly do observe conduct that occurs prior to the consumer purchasing decision, but also, as some of the examples I've mentioned suggest, conduct that occurs after that purchase occurs. We do consider that the prohibition as framed does, in effect, cover that before and after the particular transaction has occurred, and the likely to words are certainly an important element of that. The reason that we have advocated for some of those additional grey list items is really to bring additional clarity to that proposition. And we note that there is also opportunity to, in the explanatory statement also takes the opportunity to clarify that the law is intended to apply in that broader set of circumstance, which we do consider to be important. It is much more than simply at that point of transaction that the unfairness can occur. It can indeed cause transaction.
I just want to ask, you were talking before about the need for businesses to perhaps make some changes in order to comply. There is a deadline attached to this legislation in terms of a transition period for businesses. Are you satisfied that that's enough, too much, or too little? Early 2027.
The transition period obviously is old. Oh, I beg your pardon, Senator. I didn't catch that. Sorry, I just missed that last part of your question.
Sorry, I was just asking your view of whether you think that that transition period is a reasonable amount of time for businesses to comply with the changes they would need to make in relation to compliance with the legislation, whether it's too much, should be brought in immediately, or that is entirely reasonable.
Thank you, Senator. Look, we do consider that is a reasonable period of time. It's a fairly typical transition period, and of course it comes in circumstances where consumers are currently experiencing harm and detriment as a consequence of the absence of this law. We have taken a number of cases where the court, if, for example, in the Medibank private case, concluded that the trader there had acted harshly and had acted unfairly, but the conduct did not reach the threshold of unconscionability. So it is an example that there is harm that is occurring to consumers in the marketplace, but at the same time a recognition that businesses do need time to consider the impact of new law and the impact that it may have on their current business practices. But equally, of course, we are really asking businesses to examine whether they are confident that the practices they are engaging in presently are honest and fair vis-a-vis their consumers.
Thank you. Thank you, Chair. That's all from me.
Thank you. I wanted to just ask about the change in terms of removing the word unreasonably from unreasonably manipulate. So just interested in your views on that, and what would be the impact of reintroducing it in terms of narrowing the law too much, or other kinds of consequences from the adjustment from the original drafting?
Thank you, Chair. We do consider that was a very important change. We are aware that part of the discussion as these laws have come into being is a concern not to, on the one hand, unreasonably constrain legitimate advertising behaviour, but on the other hand, not to set the bar too high such that is causing harm and detriment is not captured by the provision. And we think that the removal of the word unreasonably from manipulate, but the retention of it in relation to distort, properly strikes that balance because it is recognition, in our view, a proper one, that there is a degree to which the purpose of advertising is to distort. So the unreasonable element raises the bar there. But of course, manipulation is another step again. And in the world, we're seeing increasing capacity to utilise consumer behaviour, both in an online and an offline world, in a way that really removes that autonomous decision-making from a consumer. The prohibition on, unreasonably manipulating, we think would set that bar too high and risk us being back in a world where harm is allowed to continue because of that framing. And of course, there is also the very important second of the prohibition that requires detriment. So it's only when all of those boxes are ticked that the prohibition comes into being. And we think that that is a very appropriate balancing of a number of factors.
Mm-hmm. Thank you. I asked about the question of limiting detriment to purely financial or material harm to some earlier witnesses. And we heard examples and evidence around the need to have a broad concept of harm outside of financial. In the view of the ACCC, what's the implication of this?
We also consider that it's the detriment requirement is appropriately framed and strongly agree both that it should extend to non-financial harm and also that the threshold of material or other words of that kind would set the bar too high. So firstly, in relation to non-financial harm, there are material examples of non-financial harm injury from an unsafe product. As an example, likely there are financial elements that will come with that, but clearly it goes beyond that. But time, frustration, maintaining a product that you actually don't want anymore because it's too difficult to get rid of it. These are all examples of harm that we consider go beyond financial. The other reason we are very strongly supportive of the threshold of detriment is particularly in our increasingly mass market economy. It is very important, and it's a competition point as much as it is a consumer protection point. Whilst small amounts of harm or detriment, whilst a piece of detriment or harm may seem relatively small to a consumer, if you are able to cause that harm, financial or otherwise, or detriment or otherwise, across a very large number of the benefit to the entity that is engaging in that conduct can be cumulatively material, sometimes very material indeed, and that is then a detriment to businesses that are seeking to compete in an environment that is effectively skewed against them by those unfair trade practices.
I had not thought about it like that. That's very interesting. Can you give an example of, if you can think of one, of what that would be? Because I had thought particularly about the consumer, but the impact on business of a cumulative small harm, I flips it around in a way that I hadn't considered.
So an example that springs to mind is perhaps a small fee that might sneak into a consumer transaction. It's per consumer, but if you are conducting transactions with hundreds of thousands or even millions of consumers, it does not take very long before that fee is a very, very material financial advantage, unfairly gained.
Yeah, and to the detriment of other businesses. So it's not that kind of... Yeah. Okay. So it takes away a bit of a level playing field for business.
That's exactly right.
Sorry. Okay, great. Thank you. I did ask about Section 48A to earlier witnesses in terms of the question about whether there is a need for it or not. I was wondering if you could talk a bit about the harms that have led to its inclusion from your perspective, particularly around drip pricing and hidden fees, and why you think that the current Section 48 doesn't sufficiently address these issues.
Thank you very much, Chair. We do very much support this reform, the element that requires prominent disclosure of transaction-based fees alongside base prices, and we consider that it enhances the existing provisions of the Australian Consumer Law, including Section 48. And the reason is that if a business discloses part of the price for a good or service, of course, Section 48 requires that it also disclose the minimum quantifiable price and figure for that good or service to be at least as prominently. But whole of transaction fees don't form part of the minimum quantifiable amount for the purposes of compliance with Section 48. So this adds to the disclosure that a consumer will receive. So if we're engaging in a transaction and I'm buying tickets, if there is a fee that applies to each of those tickets, Section 48 requires that that is disclosed as the full price. But if there is a transaction fee that applies whether I'm buying one ticket or 10, that's the part that has not been covered by 48. So this means that that part transaction will also be clear to consumers. And it's important because sometimes those additional fees can be a material part of the price that the consumer ends up paying.
Mm-hmm. Yeah, okay. My final question is about some work that you're doing. So I understand that you're currently assessing a designated complaint from the Consumer Action Law Centre around lead generation and unsolicited selling. I was wondering, to the extent that you're able to provide us with an update on that complaint and what the next steps and timelines might be.
Thank you, Senator. I'm not able to really answer that much in the way much substantively, but what I can say is that we expect in the reasonably near future to release a report that responds to a number of the issues that were raised by the consumer action complaint, including any recommendations that we may consider appropriate, arising from what we've seen in that complaint. But I'm not in a position today to talk about what those recommendations will be.
I appreciate that. In terms of the timeline, are you able to share? I think you said soon?
I might check with my colleague, Ms. White, to see if she's able to be a little more specific than I have been.
Thank you, Katrina. Yes, Chair. I think we're hopeful within the next 2 months to have something.
Okay. Yeah. All right. There's been some discussion earlier about lead generation and, questions about where that sits. And so I think it's just helpful to have a bit more of an understanding about where some of this other work is going on. So that's useful. Thank you. That was the last of my questions. Deputy Chair, do you have any additional questions?
Just the one, thank you, from that conversation. I'll just refer you back to some of the comments that were made in relation to the ticketing example. And I want to ask, so currently under these amendments to this legislation, if you're a small business and you are using a platform, a bigger company actually owns the platform, who do you actually see as being liable under these changes to the legislation? Is it the platform that somebody is using, or is it the small business that is using that platform?
Thank you, Senator. That is a question that would have to, I think, be based. It would depend on the facts and circumstances of a particular matter. But I can certainly say it would be our expectation that both a platform provider of ticketing services and indeed a small business seeking to utilise such a platform both ought to be aware of the provisions of this law and carefully examining both their terms and conditions, but also their more general interface with consumers to be confident that it complies with the provisions of this law.
Thank you. Thank you, Chair.
Thank you very much. So that concludes our questions for the ACCC. Thank you very much for coming. And I will now welcome Ms. Anna Barker, who I see on the screen, from the Department of Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My full name is Anna Barker. I'm here as the Acting Assistant Secretary for the National Competition and Consumer Branch within the Market Group of Treasury.
Thank you very much. Do you have an opening statement that you'd like to make?
Yes, thank you, Senator. I just want to put on the record that addressing unfair trading practices is an agreed policy priority of Commonwealth, state and territory consumer ministers. Development of the reform has been ongoing and informed by extensive stakeholder consultation and analysis, including public consultation in 2023, 2024 and 2026, and analysis undertaken by the Treasury around the regulatory impacts as well. The Competition and Consumer Amendments Unfair Trading Practices Bill 2026 was introduced into Parliament on 1st of April, as you know, and if passed, that has that general prohibition on practices that manipulate consumers or unreasonably distort the environment in which consumers make a decision causing detriment. It strengthens protections against drip pricing by requiring transparency of transaction-based charges and introduces protections against subscription practices that are detrimental to consumers and small businesses. Under the proposed laws, businesses that offer goods or services through subscription models will be required to clearly disclose key information before signing customers up for a subscription and provide customers with a way to end the contract, ensuring that it is easy to find, straightforward, and only requires the customer to take steps that are reasonably necessary. The general prohibition is not intended to stop legitimate marketing or capture ordinary reasonable business practices used to influence consumers. It aims to restrict manipulative practices which cause or are likely to cause consumer detriment without prohibiting normal advertising and competition. In respect of subscriptions and drip pricing, the bill enables certain matters to be prescribed via regulations. For example, regulations to impose notification requirements for subscription contracts. This could include requirements to notify customers at key stages, such as when a free trial is about to end. Developing regulations usually involves public consultation, including through the release of an exposure draft. However, that's ultimately a matter for government. As has been discussed this morning, as proposed in the bill, reforms will not commence until 1 July 2027, and the intent of that was to allow time for regulators to develop guidance and conduct education awareness raising activities, and to give businesses the opportunity to understand their obligations and adjust their practices as necessary. I just want to signal as well, the government has announced it will extend unfair trading practice protections to small businesses, including businesses regulated under the Franchising Code of Conduct. And on the 3rd of July, Treasury released a consultation paper seeking feedback on the design of protections for small businesses and franchisees, including whether a principles-based prohibition should apply and whether specific unfair trading practices should be targeted to protect small businesses in business-to-business dealings. And that consultation is open until the 10th of July. And also just to note that the bill as drafted does already extend to subscription protections for small businesses in respect of standard form subscription contracts. So I just wanted to give that opening statement. Thank you.
Thank you very much. We'll go to questions now. Senator Little, do you want to go first?
Happy to do that. Thank you, Chair. I'd just like to understand whether you're aware of consultations that were done before the drafting of this bill.
Yes, a number of consultations have been undertaken, as I noted briefly. So this was agreed as a priority a couple of years ago, with the first consultation undertaken in 2023, I believe, with a consultation regulatory impact statement. So that was in August 2023 on behalf of Consumer Ministers. The Assistant Minister Treasurer, the Honourable Stephen Jones, released that consultation regulatory impact statement. And that was really seeking evidence on the nature and extent of unfair trading practices and the extent of consumer and small business harm arising from potential gaps in Australian consumer law. And that undertook consultation on four policy options at the time, which was status quo, amending statutory unconscionable conduct, introducing a general prohibition of unfair trading practices, or a combination of general and specific prohibitions on unfair trading practices. So at that time, Treasury received 79 submissions, including 8 confidential submissions. It held 9 bilateral meetings and 3 roundtables. and the non-confidential submissions have been published. And out of that, option 4, which is, as you can see, reflected in the bill, was the one that got the most consultation support, followed by option 1. There was then a supplementary consultation paper in 2024, and that was on the design of that option 4. And in November 2024, the government released a supplementary consultation paper to amend the ACL to make both the principles-based general prohibition and the specific prohibitions. So that then had the grey list and options around unfair subscription-related practices, and also looked at drip pricing, dynamic pricing, online accounts requirements, and barriers to accessing consumer support. That consultation ran between the 15th of November 2024 and December 2024, 13 December 2024. It had 59 submissions, including 6 confidential submissions. And again, Treasury held a number of bilateral meetings and roundtables with stakeholders. And those non-confidential submissions have since been published. That feedback informed the decision regulatory impact statement that Treasury undertook. At that time, there was then consultation with the states and territories, because all ACL amendments require support of states and territories, at least 4 parties, including at least 3 states. In November 2025, states and territories agreed to the proposal to amend the ACL to introduce unfair trading practice protections. Then there was an exposure draft consultation. Sorry, it's been quite a bit of consultation undertaken between the 9th of February 2026 and the 23rd of February 2026. From that, we had 58 submissions, including 9 confidential, and those non-confidential submissions are now available on Treasury's website. Happy to provide more on any of that. But
I'm particularly interested in some of the number of submissions from business representative organisations that actually asked for exemption for small business from the general prohibition on unfair trading practices, but also recognising and drawing to the attention the failure to extend the general prohibition to business dealings, in that this legislation restricts those protections to consumers only. I'm assuming that through all of those consultations, that would have been pretty consistent feedback. What I'm really asking the question as to how is that not reflected, do you think?
Yeah, thank you for your question. Certainly business groups were consulted and did provide submissions, including larger and smaller business groups. There was consultation. The first consultation did look at that in respect of small businesses and consumers, as we do under many ACL provisions. It wasn't an intent not necessarily to do anything on small businesses, but rather to move quicker on the consumer elements, and that's why that was put forward to progress more quickly. I think that the issues, as will be seen from the consultation paper that's just been released, the issues are a bit distinct between how these unfair trading practices, what type of practices these are, how they affect consumers versus small businesses, and especially those relationships between business to business type relationships have different characteristics. So I think it was more from the evidence being a bit clearer in stakeholder feedback around what we're trying to capture and address for unfair trading practices for consumers versus for small businesses. And so that's the basis on which the consultation is being undertaken at the moment. So it was more not wanting to slow down consumer reforms while there was a bit more time to consider how to extend those to small businesses. It has been extended, as I noted before, already in respect of subscription arrangements. So small businesses are already covered there. I think there was just a want to understand better whether extending the existing provisions that are in the bill to small businesses does address the types of harms and issues that have been shared through consultation, or whether something different is required for small businesses.
Right, because that's clearly reflected in many of the submissions from a pretty broad range of business interests, is that it's almost like they too want to be included in these protections, but in this legislation being put to us now, they're not.
So I think there are different views as to like the types of unfair trading practices that can apply for small businesses. So while I think there's a lot of interest in having the protections against unfair trading practices for small businesses, what exactly those unfair trading practices are and how you should best categorise those in the law to prohibit against them, I think there are differences of opinion, which this current consultation is meant to try and sort of flush out a bit more.
But you did do pretty extensive consultations, which would have been pretty consistent with the views that I've just proffered to you now. So
yeah, I think there have been other developments, and this is discussed in the unfair trading practices consultation for small business. There's been other developments that would have an impact on some of the conduct that has been captured. So there have been a lot of changes to industry codes, for example, over the last few years. There's been some other changes to the CCA. So there was a want to try and get more recent submissions on the types of conduct there as well.
What about carve-outs? Was there any consideration or any work done on whether there could be carve-outs rather than just a broad approach to who would be impacted by this? Were there any considerations given to carve-outs that might be quite
for types of business or for types of consumers? I haven't been around for the whole of the consultation, so I couldn't say exactly what has and hasn't in many iterations been ruled in and out. Obviously, for now, the protections don't apply to small businesses, and that's given effect through the bill, and that was really to try and, again, understand better. But I mean, generally the ACL and the CCA we do tend to have economy-wide protections, and I think for good reason, so that you're not having different things applying to different parts of the economy. And so that's sort of consistent with the ACL more generally, to go with the principles-based being economy-wide.
Okay. What about for protections? I raised, and I think you might have been listening online then, the issue of small businesses that use big business platforms in order to sell their products or services. Are they all equally liable under this legislation as it's currently presented?
I think, again, as in respect of impacts on consumers, I think the ACCC's answer sort of went to this. It would probably depend on the circumstances of the specific case as to who was liable in these circumstances, but we would be expecting all businesses to be compliant with these obligations in respect of consumers in the way they represent themselves to consumers. And ultimately, it's a matter for the courts to decide liability.
Mm-hmm. Okay, thank you, Chair. Thank you very much.
Thank you. I wondered if you could talk a little bit about the grey list, particularly around its intended role. You know, we've heard this morning, and the submissions cover a range of views about that. So I wondered if you could talk a bit about, you know, what is the purpose of it in terms of being exhaustive or guidance, and how businesses should treat practices that are not listed on the grey list.
Thank you, Senator. So I think what the intent of the design with a general prohibition and a grey list combination was really to have some flexibility. With a general prohibition, that's obviously meant to be sort of future-proof. It's meant to capture a broad range of practices that fit within the definition in the law. And the purpose of the grey list, I guess, is where we've seen the types of conduct that we think does fall into unfair trading practices. We can say, here's an example of a type of practice we think is contrary to it. So it's certainly non-exhaustive, and it's more an illustrative list, and that would be the purpose there. And again, something that can be consulted in respect of the specific circumstances, and also meet the test for the general prohibition. So I guess there's some benefits as well for businesses and consumers in that it reduces some of the uncertainty. Where they have a grey list, they can sort of see the types of things they should be avoiding as a business, and consumers can sort of understand better their rights in respect of the unfair trading practices, especially because this is a new type of economy-wide protection. In the 2024 supplementary consultation, there was a lot of support for a grey list, and support that its inclusion would provide greater clarity and guidance to businesses and regulators on how it would be interpreted and the types of conduct which would be likely considered an unfair trading practice. It was also something that was highly supported by consumer advocates, especially in conjunction with the broader principles-based approach. It's also something that has been used elsewhere, so under our unfair contract terms provisions in the ACL, that's a similar approach that's been used there. It's also an approach that has been used in other jurisdictions, so it's sort of consistent with those types of things as well.
So when you were talking there, you mentioned the list can be consulted around specifics. What did you mean? What did you mean by that exactly? When would that consultation occur, or has it?
Oh, sorry, I meant when businesses are coming to comply with the new law, it's something that they can look at as the types of conduct that unfair trading practices, like what it means. So indicative of the types of conduct. Sorry, that's what I meant.
Yeah, thank you. I think you touched on the issue around the 12-month transition in your opening statement. I just wondered if you could talk a bit more about the design of the bill to minimise unnecessary compliance costs and, the thinking and work that's being done to try and reduce the burden on business.
Yeah, so that was obviously something that was considered through the decision regulatory impact statement, looking at the regulatory compliance costs associated with this. I mean, usually when you have new obligations of this type, there are going to be some regulatory costs associated with that, and that was certainly what was found in the Treasury estimates. However, while it couldn't be fully quantified, it was expected that the benefits from the protections would greatly outweigh those new compliance costs. I think in the design of it generally, it's been something that has been front of mind. And one of the reasons why, things like the grey list can be helpful in sort of identifying what can be done. I think the use of regulations as well around things like subscriptions is going to be helpful to allow for a little bit more flexibility to make those work as they should and help businesses comply with those types of things. I'm just seeing if there's anything else. But I think it's something that's sort of been considered the whole way along, and certainly if you look at the explanatory memorandum as well, it goes to clarity around what is meant by these things and what is also not meant. So it's certainly not meant to be capturing all forms of advertising or sort of normal acceptable business. And certainly that is trying to guide both businesses through their compliance activities, but also like the regulators and the courts ultimately, hopefully, will have regard to that. There's also funding in this budget just we had for the ACCC to undertake further guidance and help with compliance and education activities with businesses generally as well, which will help again with those compliance costs.
Yeah. We've talked a little bit this morning about a couple of other witnesses have talked about an opt-in requirement. And I was just interested to hear from you in terms of the consultations, Treasury, the consideration that you had around adopting an opt-in requirement for free trial conversions. What did the stakeholders say, and then why did Treasury land on a notification-based approach instead?
Yeah, so that was a proposal to have consumers opt in to continue a subscription-free trial. Yeah, no problem. So that was something that was consulted on as part of the supplementary consultation on those 4 options to address harmful subscription practices. And that was as part of option 3, which had this opt-in requirement to basically make businesses seek an active opt-in from consumer rather than opting out. So that was certainly something that was consulted on. Stakeholders did raise concerns about whether or not that opt-in requirement would have higher regulatory costs for businesses. I guess the way most businesses have structured these types of things is on the basis of a free trial that a consumer opts out of. So even those businesses who were doing a really good job already notifying consumers and basically making it very easy for them to opt out would have to change. It would require basically all businesses, I think, to change their practices to go from an opt-in to an opt-out model. So there was certainly consideration of the compliance costs associated with changing that. And the trade-off of whether or not it gets you to a much better outcome than opting in with a lot better transparency and notification of the free trial ending soon, and the requirements around making opting out so much easier as well. So it's also consistent with other comparable jurisdictions. So the UK elected again to not include an opt-in requirement as part of its subscription reform. So that's quite a good example of where the regulatory costs were taken into consideration in the design of it.
Okay. Thank you. I just wanted to ask about Section 48A. I've asked this of other witnesses as well, but just in terms of this idea that stakeholders have suggested, some of them, that there isn't a need for 48A, and wondered if you could talk from the perspective of Treasury around what you heard in terms of the harms that have led to its inclusion, particularly around drip pricing, hidden fees, and the gaps with the current Section 48.
Yeah, so you're right. This was something that stakeholders did raise as being a gap, and something that the new protections needed to address. So Section 48 requires the single price to be specified in certain circumstances. The display requirements under the new Section 48A do not dictate the price that must be represented. It only requires the display of a transaction-based charge in relation to a base price that is displayed. So a person should consider their requirements to display the single price for goods or services under Section 48 before making any price representation. So it's certainly not meant to be replacing 48 in any way. It's meant to be complementary to. The drafting of this did seek to avoid impacting the existing obligations. And it's really a separate requirement that applies where a business makes a base price representation. It requires a business to disclose any per transaction fees and whether they're included or excluded from the base price, and the base price being the price payable for those goods or services themselves. The issue is the base price may not be static throughout the transaction process, and the obligations will apply whenever the base price is displayed. It means the information required to display for the transaction-based charge might be different at different points in the transaction process, but the consumer along the transaction journey is operating under the best information as they go through that transaction. So this will ensure potential buyers are aware of any mandatory transaction-based charges and allow them to make informed decisions throughout that transaction process. It is, it's ultimately about the fact you do have these different, fees that may apply to a transaction separate that are hard to, I guess, capture when you first start a transaction. And it's really meant to address the type of conduct where a consumer's gone into making a purchase without that full information as they go. And the price gets higher as they go along. And this is really meant to capture that type of conduct.
Okay. I think that was all I had. Senator Little, do you have any follow-ups?
No, thank you. I'm fine. Appreciate that.
All right. So I think that concludes our hearing today. Thank you very much for appearing, Ms. Barker. So we will now conclude today's hearing. Thanks to all of the witnesses who appeared and to Hansard and Broadcasting for their assistance, and also to the Secretariat. The committee has agreed that responses to any questions on notice that any of the witnesses have taken should be provided by close of business Tuesday, the 16th of June 2026, and the committee now stands adjourned. Thank you.
Thank you.